You just.
I don't know where Fiona is. Sorry, what do you want to do?
If you can just
Knock on the door?
yes, I will know when the judges are.
Oh.
But if it's just you,
Quincy has to leave early.
oh, is he here?
He's told me.
Oh, but is he?
But I don't know actually, no.
But we're not there.
I'm a bit surprised because they haven't said anything. I'm not worrying.
They should all have been told. The judges should all have been.
Sorry.
The judges should all have been told.
What? Not to see?
All rise.
Yes, Mr. Venables. Mr. Venables.
May it please the court, I will propose to just finish the reading from Archer in the Court of Appeal at tab 8.
Yes.
And then I'll address the question I was left with, as it were, homework over the short
Yes.
adjournment.
Yes.
So we had got, I think, to the end of paragraph 92 on page 202. If you could turn over to paragraph 95 on the next page. As to the proper scope of objections which may be raised under section 222, I've already made it clear that the section should, in my view, be given a broad and non-technical construction, with the aim of enabling all objections to the application of the three conditions or to the amount of the accelerated payment to be covered, if at all possible, by the representations. And then he gives an example relating to Mrs. Archer's case. Then just before C, I accept that there will be some high-level public law challenges to the APM regime, which, even on its most benevolent construction, fall outside the scope of section 222, including, for example, most of the challenges on human rights grounds, which this court considered in Roe. I should just say that Roe was concerned only with APNs and not with follower notices. Now that the general lawfulness of the APN regime has been established, however, I would expect such challenges to be relatively rare, and I am certainly unconvinced that any of the grounds relied upon by the artist were such a nature as to render them incapable of resolution. So that is where the point is, at the very least, left open, and possibly more than that, where representations, where an application is made on grounds that could not form the subject matter of a representation.
Maybe the next paragraph is relevant. Well, to the perhaps the point we left you with.
These reasons, it would seem I'm in broad agreement with the conclusion reached by both courts below that section 222 does in general provide an alternative means of redress for the taxpayer in receipt of an APN, which should normally be exhausted before the commencement of judicial proceedings.
What's the reference? Oh, both courts, the Master and Mr. Justice Green. Yes, I'm with you. Yeah.
Then this ties in nicely with the interesting point. If representations are made and the revenue make a determination, and in particular determine to confirm the original notice, is that determination susceptible of, in itself, susceptible of judicial review? So you can get round any problems on time limits relating to the issue of the notice itself. Now, if that were the case, that would obviously provide a satisfactory solution in every way to the problem. there would be no intellectual problems, there would be no difficulties with the civil procedure rules, and this is of course assuming that the taxpayer has no grounds for seeking judicial review which could not be the subject of representations. That's clearly a...
Well, why?
Well...
Because would not the final, so I might call it for a moment, determination be susceptible to challenge on precisely the same grounds?
Well, if I were instructed to appear for the revenue, I would say that the question of the Human Rights Act point could not be taken in an application to quash the response to the representations, because they could not have been raised in the representations, and therefore could not be dealt with in the response to the representations.
But the result is not just, the result of the process is not just a response to the representations, it is the confirmation or variation or cancellation of the notice. That's the outcome of the process.
And that, the lady, would be the response. And if this court were to say that it seemed to be a good response, that of course would be a perfect answer. But I think it's important that we do recognise that the revenue could put an argument, which you know might well find a reply of that type. I mentioned that there was a note in the White Book. It's volume 1, page 1933. And it is part of the commentary under Rule 54.5, which deals with time limit for filing the claim form. If your lordships have that, it's the second paragraph break from the bottom. And it's not at the beginning of that paragraph, which starts if the claim is for a quashing order. Perhaps we could come in from the next sentence. If the challenge is to a particular decision or action, the time limit will usually run from the date when the decision or action was taken. The claimant must, however, challenge the substantive decision, that is the real basis of their complaint. A claimant may, for example, fail to bring a challenge to a particular decision, and then may seek to challenge some later ancillary or consequential decision, or approval, I suppose that's the difficult word, of the earlier decision, on the ground that the later decision is unlawful, as it is based on the original decision, which is also unlawful. In such situations, the courts, and here it's tantalisingly, may find that the time limit begins to run from the date of the earlier decisions. And then there's an example given. The High Court has, for example, held, for example, that where a local education authority published proposals to close a school, and the claimant wished to claim that the local education authority had acted unlawfully in publishing proposals, as the wrong committee within the authority took the decision, the time limit ran from the date of the earlier decision, not the date of the decision of the school organisation committee approving the proposals.
You've got two different authorities there. I don't know. Are they two committees of the same authority, or are they?
They appear to be two different, yes, two committees of the same authority.
I see.
But it's in substance the same decision, which is confirmed. So now, of course, this doesn't bind this court. There are really two dimensions. If this court were to say, were to hold that replies to statutory representations may, under either the follower notice or the were themselves the subject of judicial review. And the time limit ran only from the time when the replies to the representations were received. There appears to be nothing to stop this court from doing so. And so from that perspective, as it were, from the general public interest perspective, that might be, well, would be a very helpful decision. Because it would obviate what could otherwise be problems.
That's right. I mean, and here we have a very specific legislative scheme, which, as Lord Justice Henderson has said, forms the overall scheme. Parliament clearly intends that taxpayers should take advantage of the representation procedure to produce, as it were, I mean, I know it's not an earlier provisional view, but if the representation procedure is engaged, then the focus is on the final confirmatory view, or maybe confirmatory may not be, as of course it was here.
Confirmatory in whole
So it's a
or in
very, I mean, so obviously whether the later decision is susceptible of judicial review in such a way as to make it OTOs to challenge the earlier decision has to be decided on the basis of that statutory scheme.
Mm-hmm.
I mean, here in the case you referred us to, they said that challenging the later decision did not render OTOs, challenging the earlier one, but of course that's, we don't know, we'll look at the case, but we don't know what the scheme was. But here we've got a very, very clear and structured scheme. And there it is. Anyway, are you, I think perhaps, I suppose in the end, what I do need to know is whether you submit that the later decision, are you submitting that the later decision cannot be the subject of judicial review?
No, my lord, but I don't submit either way, because it's not
Don't
really
submit.
material to my client's position.
But I think the Revenue have advanced this in their skeleton. So, I mean, you're entitled, I suppose, to say you're neutral on it, but I just need to know that. Really.
I'm neutral on it as far as my client is concerned. If I'm allowed to consider...
No, I think you're speaking for your client.
I speak for my client, then I'll say nothing more. I would...
No, I mean, I think yes. I mean, I appreciate the points you've made, which are perfectly properly made on behalf of your client, but you can't step outside that brief.
There is another aspect, which is the point that was addressed in Cooke, when I take this very point.
Yes.
And when I take you through it, which will be very, very short indeed, I think, you will see that the argument was put that there could be separate judicial review proceedings against the responses of the revenue to the representations.
Yeah.
However, of course, that doesn't bind this court. The actual decision has, in effect, already been overruled by Archer. And so, although it's purely material to whether M-Sport acted reasonably, which is the only point, I suppose, at the end of the day, it's my duty to put to you, that in the then state of the law, there was some uncertainty as to whether it could well have been that cocaine would be held to be right, for whatever reason. In fact, that does take us to cocaine, and this time perhaps I will go into reverse order, take your lordships briefly through the decision at tab 5, and then, tab 5 of the authority done. one little bit by way of background. This didn't concern an APN. It concerned something called a PPN, Partnership Payment Notice. However, your lordships may take it that this is a special regime applicable to partnerships, but adopts, with such consequential amendments as are needed, the APN regime. And normally cases on PPNs are regarded as being authoritative on APNs too. Right. If we go to paragraph 7, following receipt of the PPN, on the 11th of February 2015, the claimant sent lengthy written representation to the defendants explaining in terms, which is unnecessary for me to rehearse, the reasons why she believed that the PPN was invalid and should be cancelled. Then on the 25th of June, the defendant responded, providing detailed representations from response to the claimant's contentions and upholding the issuing of the PPN. This exchange of correspondence followed the scheme set out in Finance Act 2014, and in particular the provisions of sections 220 and 227. Then paragraph 9, after the defendants had upheld the notice, on the 6th of July 2015, a pre-action protocol letter was sent by the claimant to the defendant. A full response to that letter before claim followed on the 10th of August from the defendants. Further written representations were made. In short, there were then 2 further pre-action protocol letters. The first of those further letters was sent by the claimant on the 8th of February 2015, and the second on the 5th of April 2016. That second letter relied upon the failure of the defendant to withdraw, cancel, or otherwise amend the PPN, which had been served on the 17th of November 2015. Subsequent to that, on the 10th of May 2016, an application for judicial review was filed, leading to these proceedings.
Sorry, I'm awfully sorry, I'm not quite sure I have fully grasped, but this is one of the ingenious film partnership cases, but I'm just not sure I have quite grasped the statutory structure which was in play here. So,
Ingenious
we had a
was
PPN, paragraph 6 says that a PPN was issued under the APN scheme on the 17th of November 2014.
It's really a special case of the APN.
Just hold on.
I'm afraid we don't have in the authority under the legislation relating to PPNs. I don't know if my learned friend has any.
So don't worry, I'm just trying. So
Ingenious was a limited liability partnership.
yeah, no. So I see. It followed the scheme. Yes. Okay. Sorry, I was a bit slow there. Yeah. So it is the same scheme.
It's the same scheme with minor variations to take account of the fact that you're dealing with a partnership and that.
So they upheld the issuing of the PPN. Right. Okay. Thank you. Yes. So the second letter, paragraph 9, relied on the failure to withdraw. That's a slightly odd way of putting it. Why didn't they rely on the decision of the revenue to uphold?
Well,
It's just being put
it
colloquially.
could be put either way.
Well, I'm not sure. I think there is a difference actually.
What's the wording of?
I mean, it's really the wording of the relevant statute. I mean, in paragraph 7, they talk about upholding the issue. So I take it that they have followed the procedure with which we're familiar. I see that it refers to, in particular, the provisions of section 220 and 227. So, anyway.
It may be that what's said in paragraph 9 is simply a gloss by the
It
judge,
must be a gloss. All right, let's take it as that.
which may not be material in context.
No, I was just puzzled by the way it was put. Yes.
But you're quite right. There is a positive duty
Exactly.
on the revenue to act.
Exactly.
And if there is to be a complaint and it's to be judiciable, then it must be that which is being attacked.
Exactly. Right. So, it was 17th of November 2015, we have that decision of the revenue to, let's say, to uphold, is that right? Well, no, oh, sorry, no, it's a rather complicated story, isn't it? Anyway, it's not till May 2016 that the application for JR is filed.
Yes.
Right. So not surprisingly, there's a delay.
Well, we have actually got section 227 in the bundle, and it does seem to be a different thing. It doesn't seem to be unless I'm misreading it. It seems to be under a separate heading. It's at page 46 of the authorities bundle. So we have. See, section 222, representations about the accelerated payment notice, that then gives rise to the determination whether to confirm or withdraw it. But there then seems to be a separate power on the part of the revenue to withdraw the notice. So that presumably if you ask them to exercise that power and they refuse, that then is a different sort of determination. Seems just to relate to condition C. Just saying that the cocaine case doesn't seem to be a case on section 222.
Yeah. Right. I mean, the actual relevant statutory provisions are clearly very important to this. So,
Well, under section 222, HMRC is obliged to consider representation.
yeah.
That's 2223.
So exactly. So there's the provision for written representations under subsection 2 of the 90 days. 3, the HMRC must consider them, and 4, having considered them, HMRC must. And then it depends which subsection they were made under, but broadly speaking, it's confirm or withdraw, confirm with or without amendment, or withdraw until you get to C.
Then 227 seems to be an additional power for HMRC.
Sorry, 22, yes. 227.
You'll see that the reasoning of the judge isn't based on distinct. I wonder if I can.
Yes, all right. Well, we'll carry on with the reading. Yes.
Section 222 and section 227.
Yes.
Section 222, the revenue have to act, if only to say we
Quite.
confirm. Under 227, it gives them a power in certain situations. Condition C requirement. They can withdraw the notice, even though they've not been asked to do so formally. But presumably there's ongoing correspondence which has persuaded them.
Yes.
But I think I'll show you, it'll be on page 129, which we're just going to now. So we'll get there very shortly.
Okay.
How the judge seemed to have taken the view it made no difference which one of those you were dealing with.
Yeah.
So paragraph 12, the reason why Mr. Gordon, who appears for the taxpayer, contends that this application has not been the subject of any delays as follows. First is he submits that pursuant to section 227, which I've set out above, the defence is under a duty to consider and reconsider their position and cancel or otherwise amend any APN. And that continuing duty gave rise to a decision which is capable of challenge by way of judicial review when they failed in March of this year to exercise their 227 discretion in order to cancel the BPN. That was a very bold argument. We in trust law know that there's a power which you can exercise or not as you think fit, and there's also powers which you have to consider whether you're going to exercise, and the two are not necessarily the same. You don't have to be. The mere fact you've got a power doesn't mean you've got to be considering all the time whether or not to exercise it. Then going on to 14, having considered these submissions, then 13 deals with other reasons for the delay. He says at 14, having considered these submissions, I'm entirely satisfied that delay in this case is a fundamental block to the grant of permission to the claimant. The starting point for the consideration of any delay in an application for judicial review must be the provisions of CPR Part 54. Those provide that claims of this sort should be brought within 3 months or as soon as possible. True, it is in certain cases it may be possible to relax those positions, but nevertheless those circumstances will of necessity prove to be exceptional. It is to be borne in mind that we are dealing with a public law remedy, and there's an importance in the certainty of administrative decisions which cannot be left in a perpetual or potential perpetual state of flux as a result of possible legal assaults being placed upon them by judicial review applications. I am not satisfied that the decision which is said to be the basis of the judicial review proceedings is in truth the decision under challenge. It is the case that public bodies, whether by statute or by other means, have at their disposal the opportunity to reconsider at any point in time decisions which they have reached. That does not mean that if they are asked to or fail to exercise that discretion, that amounts in and of itself to a decision which is susceptible to judicial review. No authority has been produced before me to suggest that such is the case. And I think the crux is really at 16. The reality here is that the decision which is under challenge is the one which was reached on the 17th of November 2014 to issue the PPN in this case. It follows, therefore, that this application has been brought many months after that decision was reached. And he does consider the alternative, ad obiter, even if one were to take a more pragmatic approach, and to say that in truth the decision was not crystallised until the provision inviting representations under section 222 of the 2014 Act had been exhausted. As it was in this case by the early exchange of correspondence, it still remains the position that many months have passed. So he contemplates the two alternatives.
But hold on, wasn't there a third alternative? I'm getting, this is where I'm a bit lost.
Well, that's the third alternative is what he was dealing with in this case.
Yes, the 17th of November decision,
well,
is it?
yes, because what seems to have happened here is that they issued the PPN, they then made representations under the statutory scheme, they got a decision confirming it, they didn't challenge that, and they were out of time to challenge that. So then what they did is to ask the revenue to exercise its discretion under 227 to withdraw the notice. The revenue refused, and they tried to say, well, that's in itself a judicially reviewable decision. And he was saying, no, you can't conjure a judicially reviewable decision just by asking the body to exercise a power and it then refusing to exercise the power. That doesn't start the clock running again. But that seems to be
And that is what he says in paragraph 50. And that's the ratio, as my lord says.
Yes, but the comment at 16 is very powerful.
Well, not very powerful, if I may say so, because having made the comment in the first sentence, he rather takes it back in the second.
Well, it's a counterfactual, even if one were to.
Well, all right, but it's obiter.
It's
obiter. So, whereas Archer was a decision. Anyway, there it is. We have this. I think it's not very, with respect, all that strong in 16, but we have your point there.
But what you say, well, this looked as if it might conflict with Archer, and we had to be safe and issue
Well, indeed, it's that statement. The reality here is that the decision which is under challenge,
Yeah.
whether second time round, third time round, is still the original issue of the notice. And that's the bit that, of course, would worry one. And in the position of M Sport, you would say, oh, good heavens, if that's taken further,
I see that.
and we don't file proceedings now, we've lost everything, not just costs.
Yeah. So hold on.
So our submission on that is set out at paragraph 62 of the skeleton. Of the twin risks facing M Sport. And in effect, I had invented this only a moment ago. If the approach, albeit obiter perhaps, in cocaine were to be followed, it could mean that we'd be entirely out of time. So it would be sensible and reasonable to file proceedings and to ask, as indeed M Sport did, the revenue to agree to an immediate stay. The next section, I think.
Just before you move on, you were going to address us on whether cocaine is properly citable at all.
Oh, did I? Yes, I'm sorry if I've not.
It was mentioned earlier on, but we said you said you'd come to it, and we were happy with it.
Lordship will bear with me, I'll just do a search of the computer version of my own to find exactly where that is. I seem to have lost that, but I can pick it up from my learner friend's skeleton.
Yes, thank you.
Let's have two. Yes, it's page 18 of the core bundle, paragraph 22 and then 20.
Yes.
Paragraphs 22 and 23. He's referred to cocaine, and he says in paragraph 22, however, as a judicial review permission decision, it was dealing with the question of arguability. And he mentions practice direction citation of authorities 2001, one weekly law report 1001, and I don't think I need take your lordships to that, he sets out the relevant part.
Right.
A judgment falling into one of the categories referred to in paragraph 6.2 below may not in future be cited before any court unless it clearly indicates that it purports to establish a new principle or to extend the present law. And if you turn over the page, 6.2 paragraph 1 applies to the following categories of judgment. Decisions on applications that only decide that the application is arguable. Now, that wasn't Cooke. If Cooke had decided that the applicant should be given permission to bring judicial review proceedings because it had an arguable case, that would have been in point. But in fact, the decision was that it could not have permission because it was out of time. That, by no stretch, can be described as a decision that the application is arguable.
Yes, I see.
My learned friend has an alternative argument, paragraph 23. Judgment is available on bail and was in fact drawn to the attention of both the High Court and the Court of Appeal in Archer. I've already mentioned the High Court point, but does not appear to contain an express statement that it purports to establish a new principle or to extend the present law. Well, of course, that doesn't matter if it doesn't fall
No,
within
I
6.2.
follow.
But then there's the alternative point. However, even if it was properly citable authority, the 2001 Practice Correction further highlights the need to consider the context of any citable authority. So 7.1, courts will in future pay particular attention, where to sought to cite other categories of judgment, to any indication given by the court delivering the judgment that was seen by that court as only applying decided law to the facts of the particular case, or otherwise as not extending or adding to the existing law. Well, again, I submit the case clearly doesn't come within that. It wasn't just decided on the facts, it was decided on a point of law. It certainly wasn't applying any existing law.
Right.
The ratio
See the point.
is that where a public body has a power,
But no obligation
no
to come to a
obligation
decision.
to exercise it or to even consider
Yes.
exercising it, then you cannot complain that it has refused to exercise it or consider exercising
And that's
it,
paragraph 15 of Cooke.
which we've just looked at. So
Yes.
that's why we say it is, on any view, a citable authority.
Well, I see. Right, okay, well, thank you for that. Yeah.
Very briefly, ground 3.2, costs should be on an indemnity basis. I have very little to add to what is in the skeleton. The only thing I would point out for your perhaps lordship's convenience is where you can find Rule 21 of the Protocol. That's in the White Book, page 2629 at C8-005, which I think we've already looked at today. Would your lordships now like me to go back and look at the decision?
Well, what I think about I mean, you've dealt with this very fully in your written submissions. You've referred us to some authorities, including, of course, recent authorities with which I think we're all familiar. We're certainly well familiar with the principles that you're deploying here. And, I mean, as I say, you've set it out very clearly in writing. Unless there's anything in particular you wanted to add it, I think you've made your case very clearly.
Lord, I don't feel the need to add anything to what we've put in writing. So unless there's anything else,
I'll just ask you. Mr. Venables, thank you very much indeed. Thank you. Mr. Hoban.
My Lords, unless you wish me to go in a different way, after dealing with one short background point, I was proposing to follow the same order as Mr. Venables.
That's absolutely fine.
The short background point is in relation to the effect of a follower notice. Now, our submission would be that this is really of little impact to the arguments in this case, but it is important to note so it's not recorded wrongly. Our position is it's not correct to say that if you are successful in your substantive appeal, having not complied with the corrective measures, that you end up paying the 50% tax penalty. And the reason for it is put shortly, is if you are successful in your appeal and your tax liability is nil, 50% of nil is nil. In practice, an assessment of the penalty we've heard about already may take place before the appeal is determined. But you do have a right of appeal against the penalty. And so in practice, if you decide you don't wish to take the corrective action and wish to pursue your appeal, you would, and the penalty then gets assessed before that appeal is determined, you would then also appeal the penalty and your appeal would be joined with the substantive appeal.
And you can postpone paying the penalty until that appeal is...
Yes. My instructions are from Jaime are yes. Now, I should be clear here that I've taken, this is on instructions. I haven't pieced all the legislative framework together myself. But that is HMRC's position on all the background matters of how it works. So it's not quite as onerous as Mr. Venables may have suggested to successful litigants. The onerous aspect is that if you're unsuccessful, you get a 50% tax penalty.
Yes.
So if you're unsuccessful in the substantive appeal.
Yes.
And you, of course, in the interim, have the ability to challenge the follower notice by way of judicial review, which we say, as you will have seen from our initial response letter, is sufficient to comply with Article 6. So, moving then to ground 2.
Now this is this is the date of service point.
Date of service.
Can I just ask you a question of fact? I think at this point, the envelope which we've seen, was that before the court below?
I'm instructed, yes.
Can you tell me how it got before the court below?
I think it was attached to these reply submissions.
It was attached, and is it referred to as being attached?
It's not quite in those terms. It's referred to directly.
Yes, it is.
There is an envelope showing. It's not said, and it is attached.
So the envelope was attached to HMRC's reply submission. Maybe.
Or is it the illegible document at page 101? Looks as though it was attached to the first round.
Yes, it wasn't. We don't believe it was quite as illegible when it was sent in.
No,
it
but
appears to be a.
But
it was
in our bundles.
I see. Yes. Oh, yes, I see.
Yes.
Yes, we've got better ones, but in terms of what
Yes,
was
it was
before
the,
the court.
yes, you'll see the 101. Yes.
101.
That would have been it. It was.
That would have been it, but it hasn't come out in legible form in our photocopy.
Yes.
But it was the actual envelope, or just a copy?
I believe a copy. A copy with the which was emailed with the submissions.
So that went in with the original submissions, or they?
Yeah, we think it went in with the original submissions. It was then referred to in the
Yes.
reply submissions.
It's not. Is it referred to in the original submission? Sorry, just to be.
I haven't spotted it being referred
No,
to. No, I haven't.
I mean, it was just there.
It was just there with the which would make
But I just wanted to clear up that piece, that point of fact. Mr. Hoban, we don't need to trouble you on this issue.
I didn't think. So we then move to ground 3. Now, in this respect, I would highlight that the burden on the appellant is high, because what we have here is a reasoned decision as to costs. We haven't got to ground 1 yet, but I can understand, in one sense, the complaint as to the lack of reasons on ground 2, albeit I asked submission simply that, given the reply submission said this is the date it was served and the envelope, it was a closed matter, and one can understand why a judge might say, well, but I don't need to deal with that. For the appellant to succeed on ground 3, they have to say that the decision of the judge was one that couldn't reasonably be reached on a lawful basis, and that is a high hurdle. And in this respect, it's perhaps worth initially just looking at the basis of the decision, which we haven't actually looked at substantively yet. Because I make a number of points in my submissions, and a number of points have been made here in Mr. Venable's submissions that might point one way or the other, but ultimately, the starting point must be that this decision is wrong, and we submit it just can't be criticised in that way. This is at tab 3. The observations are, although the notices with the subject of the proceedings have now been withdrawn, it appears that the judicial review proceedings were premature and that the claimant should have waited for a response to its statutory representations. I make no order, therefore, for costs in favour of the claimant. Equally, I make no order in favour of the defendant in light of the delay in its response to the letter before claim. That's the decision. HMRC perhaps felt it was rather harsh on the delay in the response, but there we are. That is the decision. The first paragraph is of importance. The basis of the decision is, of course, that judicial review proceedings were premature. Whilst we have put in paragraph 40 of my skeleton argument that the appellant has not been fully successful, and that's an argument I maintain, that wasn't the basis of the decision. That, in fact, only really kicks in if you were to decide to set aside this a decision on costs. And my submission is that the appellant simply hasn't shown they can overcome that hurdle. Why was the judge wrong to consider that the proceedings were brought prematurely, when the Court of Appeal has now said that's exactly the position? Now, it matters not in my submission whether or not there were good grounds for the appellant to have done so. They were still premature. As a matter of law, they were premature. And that's the end of the matter. That's the decision. It's a perfectly reasonable basis for making the cost decision in order as to cost that was made.
Just your respondent's notice, that didn't raise the point about only being partially successful.
It is in my skeleton at 40. Was it in the notice? It may not have done.
Well, you don't seem to be, from what I gather, you said you're not relying on it as an alternative reason for upholding the decision.
It is a piece of the... Let me have a look at the respondent's notice. I think I would like to rely upon it as another reason to uphold the decision, but whether I put it in the respondent's notice or missed it out of the
Well,
respondent's
you
notice
can
is...
only do that, I think.
Yes, well, indeed. I know, I accept that. And if it's not made into the respondent's notice, I can only use it, deploy it as a shield to arguments put the other way.
No, it doesn't seem to.
I mean,
Yes,
it's quite puzzling in a way, this. Go on, sorry.
I think it's correct to say it's not deployed in the response notice. So I'm happy to only
Can I
use it
just
to
see the respondent?
respond to my...
So the first one is ground 2. Deal with that. Then I'll tell you the reason why I'm just wondering about it, actually, on a very technical level, perhaps. And that is, I think you prefaced this by saying that M and Croydon would only come into play if we were to set aside the judge's decision, at which point, of course, this court is making the decision itself.
Yes,
So I don't quite...
No, that's what prompted me to ask whether...
yes.
would it not... I'm just wondering, actually, I just don't know the answer to this, whether in those circumstances it's necessary to raise the point in the respondent's notice, because it's not actually a ground for upholding the judge's decision, it's a ground for persuading this court
No, I think that...
to make... Yes,
Respectfully, that's right.
I see, yes, okay.
If we are to get into arguments where you are...
Anyway, I think we're all pointing in the same direction, actually. So it doesn't... Yes.
Okay.
Yeah.
So I would like to quickly run through what I do put in ground 3, although I won't
Yes.
be everything in the skeleton. But I'm prefacing that because that is the... I don't have the hurdle of showing that I am right
No.
in the first instance. We start with the competing authority of Cooke and Archer. And I think the first point is the one that has already been discussed as to the status of Cooke as ratio or obiter in paragraph 16. And my submission is it's plainly obiter comment, because the ratio is in fact in paragraph 50, because it was dealing with a complaint raised on a section 227 basis,
Yes.
saying you would use this separate withdrawal power, and the court just didn't determine between which starting point, when time started to run, either when the follow a notice, sorry, the APM was issued, or when the representations were responded to. The second aspect is whether it's citable. Now, my learned friend has suggested, well, it doesn't merely decide that it's arguable. My reading of the practice direction is that it's referring to cases deciding whether matters are arguable. But
Yeah.
I can see the point. But in some ways it doesn't matter, because it is a practice direction. It doesn't mean it is a universal rule never to be departed from if there was nothing else. But context is very important. And it was a permission decision. And it is to be compared to Archer, which was a High Court decision on similar facts. And he has persuasive authority. Now, there is a side point here as to whether cocaine was brought to the attention of the High Court. My instructions are that they were, and I've seen the skeleton argument where it was, but I accept that the the appellant wouldn't have known that. It's not referred to in the judgment or any report.
Interestingly, I see that what was definitely referred to, Mr. Justice Green, and is mentioned in the report, is the local authority education case that Mr. Venables took us to in the notes in the White Book.
Yes.
I just mentioned that in passing, so that was before Mr. Justice Green.
Yes. And whilst I say that, as a matter of principle, we need not even get as far as deciding precisely the nature of the second decision that you have queried whether it is judicially reviewable, the representations decision, if I may put it that way. Our submission is that that is a judicially reviewable decision. It is a decision provided for expressly within statute, which has to be made. It's not discretionary. And of course it's made on a different basis to the earlier decision, because it is made with the benefit of the representations. That are expressly provided for. And so it is not merely an act of confirmation. The statute uses the word confirm or withdraw. But it is not merely a rubber stamping exercise. There is no suggestion that HMRC is not required to determine the matter effectively from scratch again. And it couldn't really say, well, we thought about that then and we're not thinking about it again. That's obviously very different to the question of whether or not you reopen the decision under 227. Again, it's a side issue in some respects as to whether or not the human rights arguments were separate. But for the avoidance of doubt, our position is they were separate and potentially at least would give rise to separate relief. Now, it's been raised in submissions as to whether once the follower notice is withdrawn, whether or not the claim is academic, and on its face it would be, but it's not clear that in fact that necessarily, although I make no concession, but it wouldn't necessarily mean the proceedings were at an end, because this is the category of case that might be said to fall within the test under zoo life, if you feel aware of that case, for where academic claims might proceed where it affects a large number of people. And Mr. Venables very fairly pointed out that it was a full frontal assault on the legislation itself, on incompatibility. So whilst HMRC might want to argue that it's academic, I'm sure that a litigant, there would be argument to be had. It wouldn't be an open and shut question.
Can I ask you this on the human rights point, if I just finish the note I'm making before I do? On a judicial review challenge to the second decision following the representations, would it be open to the taxpayer to raise the human rights grounds?
Yes, and the reason for that is the provision of Section 7.1 of the Human Rights Act. I'm afraid it's obviously not in the authorities bundle,
No.
but I can read it out. What it says is, proceedings 1, a person who claims that a public authority has acted or proposes to act in a way which is made unlawful by Section 6.1 may, A, bring proceedings against the authority under this Act in the appropriate court or tribunal, it's just a Human Rights Act claim, or B, rely on the convention right or rights concerned in any legal proceedings. but only if he is or would be a victim of the unlawful act. So once you can raise a public law challenge, a judicial review challenge, you can incorporate human rights arguments within them, even if the grounds for them may have arisen earlier. And that is logical in one sense, particularly here, when the interference under Article 1 Protocol doesn't even arise until the penalty is payable. So whilst obviously the arguments can sensibly be run before the interference occurs, it seems strange if you were barred and the interference hadn't even occurred.
Yes. Okay.
So that in my submission. Fine. Now I should touch upon M and Croydon, which as a shield, purely as a shield as to why
Yes.
it automatically follows the costs follow the event. We say that we do highlight that point that I've just made. There was a human rights element to this. There was a declaration in respect of breach of human rights sought. And that piece of relief was not obtained, and it was freestanding. It was freestanding for the reasons I've already expressed. The way in which the argument put included declarations of incompatibility and the potential, at least, for a wider effect that would have meant the claim could be pursued even though it was academic for the individual claimant. In that respect, there was a question raised as to what was meant in M and Croydon at paragraphs 59 and 60, which Mr. Reynolds took you through, as to success.
Yes.
One of the points here is, even if I'm wrong about that, and this is a success case, it's a starting point. As with all civil procedures,
Yes.
it's the normal proceeding, it's the normal rule, and that you can depart from the normal rule in the right case. So it's not the case that it's a hard and fast position. I think Mr. Venables used the word, well, it may be rough justice on the defendant if they end up paying all the costs. Well, equally, why should it not be, in the appropriate case, at the discretion of the judge, rough justice on the claimant that they don't get their costs back? Nobody's suggesting here, for example, that they should pay HMRC's costs of defending that point. That deals, I think, with ground 3. Ground 1.
But before we go, can I just explore a little bit more, if I may, about Archer? You say, well, the effect of Archer is, at first instance, and it was affirmed on appeal, it demonstrates that this application was premature. Now, it does look as if Archer proceeds on the basis, you may be able to show us this isn't quite right, but proceeds on the basis that there would be a need to extend time for the challenge from the original decision, but it would be very unlikely that time would not be extended. Now, is that a fair reading of Archer, or?
It's not entirely clear. I would accept that. My initial reading, in fact, was that they were implying there was another decision to be reviewed, which is why I put it that way in paragraph 18, referring to Archer. And I maintain that the position I put in paragraph 18 is correct. I would accept there is certainly some doubt as to exactly what the ratio.
Do we? I mean, were you in that case?
I was.
No. Do you know whether the argument was put forward? You may or may not know that there was a second decision. And the challenging the first decision was premature because you could wait to the second decision and then challenge that. And that there was the alternative procedure and so on.
I am not sure. I'm afraid. Unless instructed.
I mean,
Now, the oddity is that they refer to time for reviewing the first decision only starting to run after the second
Yes.
decision. And that's a kind of an odd, it's not saying that time runs because it runs from the second decision, but I can't quite see how
Let's have a
the
look at
3
that.
months cannot start
No,
to run.
can we just see that? I think it would be good to see exactly how
Is that
Lord Justice
my-
Henderson
my
put that.
recollection? Or-
This was the per curiam bit, wasn't it? I think,
Yes.
but
92,
it's 92 105 apparently. I don't know why they say 100.
well, that's just where the other two are.
But it's actually only where Lord Justice Flo agrees. Lord Justice Floyd doesn't count for these purposes.
It's all on that,
Anyway,
one
it's-
sentence in 92, isn't it?
It's
The
90.
per
It's
curiam.
all on 92. What procedure?
Well,
Begin. It. Hold on. Where there has in good faith made. Hold on. Where Parliament has provided a potential alternative remedy, the court will, if necessary, ensure the taxpayer is not prejudiced by taking advantage. So, for example, in case where the taxpayer in good faith made representations, HMRC's response is not notified until more than 12 from the date of the APN. I would expect the court to proceed on the basis that time does not begin to run for judicial until the. Well, it does really read on the basis that it's the original decision which is still to be the subject of challenge, doesn't it?
yes, it may be that the thinking behind that, to expand it more,
Yes.
is based upon the wording of CPR 54.5, which of course refers to not less than 3 months after the grounds to make the claim first arose. And it may be, if you read grounds as being, well, you don't have an alternative remedies have also been exhausted, then that's when your grounds arise. Because one answer.
Sorry, this is 54. This is what we looked at this morning, wasn't it?
Yes,
Yes.
54.5.
Not later than 3 months after the grounds to make the.
Yes. If you were to read that
I see.
purposefully.
Yes, but I mean, I see. Yes, query.
Grounds here is the decision. I mean, grounds judicial review can be against all sorts of things which are not a decision. Most usually the application of a policy to someone for the first time. That was that case about the people in detention only being paid £1 an hour. And the policy had been in place for a long time, but the grounds of these detainees to challenge it only arose when they were detained and started working for £1 an hour. And that was, there was no decision to apply it to them, that it was just the first time that they had an interest in pursuing it.
Well, that would encourage, in my submission, a holistic view as to the meaning of the word grounds, which is, i.e., when can you bring the claim? Which is a matter of not just looking at the date of the decision, it's looking at the context. Another example, there is a similar example, of course, in regularly comes before this court, which is immigration. Immigration decisions are now subject to administrative review, which is a very narrow review jurisdiction, but nonetheless it's now the position that time starts to run from the date of the administrative review if you bring your administrative review in time. And you could still challenge the earlier decision, but nobody has any doubt the earlier decision is the key one, because most administrative review decisions are simply a confirmation exercise because their scope is so limited.
Well, I mean,
As I
I
say,
think
that's-
that I mean that's your reading of that sentence and notification. It is a possible reading of it. I mean, I'm inclined to think that the argument that it's premature because you can challenge the second decision and you should run through the whole procedure and get to that determination and challenge that argument was not put in what Mr. Venables would say was a full frontal way. Because I can't help feeling that the court would have dealt with it if it had been put clearly in that way. So inevitably they're dealing with the submissions made to them.
I can.
All right.
I have the skeleton argument before the High Court.
Oh,
I can read you one paragraph which may or may not be illustrative. HMRC submit that where Parliament has provided for an express mechanism for HMRC to withdraw, vary or confirm a decision before the taxpayer is required to take the action as a result of the decision, the mechanism engaged, time should start to run for judicial review purposes from any confirmation, etc.
Well, that's
So-
the wording they've adopted, isn't it? It's
Which is-
slightly odd.
Which, yeah,
is it?
Yeah.
our position has been throughout that that's when time starts to
Time
run.
starts to run.
Well, that
But
must
whether or
mean
not
time
it's-
starts to run for the second decision. I mean, that's how I read that,
But
but
it
maybe
could
it's
be
slightly
either way.
misunderstood. Yes,
Could be either way.
could be either way. Yes, all right.
But the conundrum is that they don't seem then to jump to the next stage, which is, so there's no exercise of, there's no extension of time needed, there's no exercise of discretion
Yes.
on the court, but that wasn't clear.
That's the sort of slight point about paragraph 92 is that it appears to still to make you dependent on an exercise of the court's discretion to extend time to challenge the first decision.
Yes, whilst I say this, it's absolutely correct that extension of the time are not in the hands of the parties. Decisions themselves, though, are maybe in the hands of public authorities in the right circumstances. They can often choose whether or not to remake a decision, withdraw and remake a decision. And so it's not, in this context where we're talking about HMRC making what is a fresh confirmation decision, if HMRC is to say, we treat this, we consider this to be a fresh public law decision, applying our minds afresh to this question, it would be, at the very least, very strong for a court to go behind that decision of the public authority that says, this is our decision, this is the decision
Yes,
you should be
but
concerned
that means that it's that decision which can then be reviewed.
Yes.
No
yes.
need to extend time.
Indeed.
All right. Okay. Well, there we are. Thank you for your anything else on that. I think you've helped us on, what the court was saying there. Right. Yes. Sorry, you were then going on to
Failure to give reasons.
Well, yes. I mean, we know what Mr. I think you probably deal with this in your skeleton
Yes.
as well. I mean, in a sense, I think we've heard you say it. I mean, the bull point in this case, you say, is that the claim was premature.
Yes.
C. Archer. And that's the reason the judge gave.
Yes.
She did refer to the submissions made on the point about like breach of the protocol at any rate
Yes.
and late response, and said that resulted in there being no order for costs. You say there wasn't anything more for the judge to say as your submission.
Yes, absolutely. Yes.
I mean, if there's anything else you want to add to that, by all means do. But
No, the only thing left over, of course, is whether or not I need to address you on whether the decision should be upheld on different or additional grounds.
this is on the protocol point, is it?
Yes.
Well, let's quickly see this point. Should we look at your?
The skeleton starts at paragraph 42, page 24, bundle.
Paragraph 24, did you say? Sorry, misheard you.
Page 24,
24.
paragraph 42.
Oh, 40, thank you.
And for this, we have to go back to the pre-action protocol, which we've already looked at in the relevant paragraphs.
Let me just. Yes. Okay. Sorry, you'd like us to look at.
The pre-action protocol.
Yes.
Briefly, I've not very long time.
Yes.
We've already looked at the key bits. Paragraph 21
Yes.
is important. It's accepted that there's 14 days to respond, but there's provision for an extension under paragraph 21.
Yes.
Send an interim reply and propose a reasonable extension.
Mm-hmm.
And in our submission was a reasonable extension of time. A week to what was a complex argument, albeit that ultimately the key response perhaps could have been dealt with quicker, which is just to say you're premature. Then we would have had the complaint that Mr. Venables made but has been withdrawn, but nothing else was responded to.
Yes.
The reality is here, as we've already discussed, the claimant had time before they had to issue, not very long, but time. It's accepted that the work might have had to be done already to prepare the grounds, but firstly, that is the responsibility of the claimant. They decided when to send the pre-action protocol letter. They obviously take a risk whenever you enter into litigation, and of course that still doesn't justify, once you've had an answer to your claim that shows why it shouldn't be brought, then putting HMRC to the expense of defending it. What you might do is say, well, why didn't you tell us this a week ago? We wouldn't have done the work, we want our costs, and have an argument about costs. In that sense, or some such, bring it before the court in that way. And it has to be remembered here that not only was the claim issued on the 5th, it wasn't served until the 18th. At which point there had been time to consider HMRC's response. It didn't have to be served. And it was service, of course, that triggers all the costs that HMRC has to bear. And of course, on the 18th itself, on the morning of the 18th, Archer was handed down. So again, there was an opportunity before the HMRC's acknowledgement of service went in to say, actually, we've seen Archer, we're not proceeding. So there are a number of opportunities here. So the simple point is we say the judge erred in suggesting that HMRC had not followed the pre-action protocol. We say HMRC had done exactly what the pre-action protocol suggests, and in fact we should have been awarded our costs.
But you're not seeking that?
We're not seeking.
No. All right. Anything else?
Well, just to be absolutely clear in my own mind about if the situation is that you serve your APN, the taxpayer on day 80 puts in their representations. There's no time limit then for HMRC to respond. So suppose they take a further 80 days to respond. They confirm the notice. Suppose then there is a 3-month period for judicial review of that confirmation. Now, as I understand it, the penalty is not payable over that 160 days. But if they decide then to, after they've had your response, they decide after a couple of weeks, well, let's just pay, then is there, what happens with the interest on either the tax or the
You may be going. We're going into the limits of my knowledge.
Well,
but,
it's just that if the pattern that becomes established is that actually everything waits until HMRC's response to the representations, that may be quite a while. I'm just wondering whether the taxpayer is prejudiced in any way by being batted back if they try and bring the judicial review claim promptly after the initial APN.
Interest may run from when the tax should have been paid.
Well,
Can we just break it down a bit?
No penalty at all. No interest on it.
You've got to have a
I'm told no.
penalty before interest is payable. I mean, my understanding, yes, I think my understanding from what Mr. Venable said is that after, let's say after the final determination, there then needs to be an assessment of the penalty, or an assessment of the denied value, or however the phrase is, and there's 50% of that. And so that's a process of assessment, which then produces a penalty against which you can appeal. And you may well then be able, but interest can't start to run surely on the penalty until it's assessed and the period for payment has expired.
Yes.
Yes.
That's his.
So that, so far as the underlying tax is concerned, well, interest runs from the date that tax was payable, unless, of course, the appeal succeeds in the tribunal.
Yes.
Yeah. But the assessment of the penalty doesn't then take place until after HMRC is sure that there are not going to be any representations under section 222, and if there are, then it's responded to them. Is that?
Yes. Yes, the assessment cannot take place until the 30 days has expired from the decision on the representations, or the 90 days has expired for representations and none have come.
That's fine.
Right, well, that's anything else? Well, Mr. Hoban, thank you very much indeed. Mr. Venables, any reply?
If I may take just 1 minute.
Of course.
It's very, very brief. It's on the question of did the claimant file prematurely on June the 5th, should they have waited for 2 or 3 days? Which was a possible argument. And the one point I would make on this is, although they received very late on June the 5th a response from HMRC to the pre-action protocol letter, it did not include any response, any substantive response, on several of the grounds, namely those the subject of the representations.
No.
That didn't come until July. So, in particular, and that included response on the very ground on which HMRC eventually decided to withdraw the notice.
So are you saying that by sending a pre-action protocol letter, the taxpayer can accelerate the time within which HMRC can respond to the representations?
No.
Can shorten the time available?
No, I wouldn't submit that. No, I'm not submitting that for a moment.
But if you're criticising them for not responding to the grounds in your representation in that the letter in response to the pre-action protocol letter, that is what you're saying.
I think I've not made myself clear.
Right.
Perhaps like it, in that the pre-action protocol letter included all the representations which have been made in the representation.
And they didn't reply to those.
And so, in replying to the pre-action protocol letter, if they had said, "Oh, we've considered this point," namely that one condition wasn't satisfying, and therefore we are withdrawing the notice, then of course the argument that we filed on the 5th rather than the 6th or the 7th might have had some point, but they didn't. They didn't address that.
I'm not quite sure the point you're making there.
Well, the point I'm making is that we can't be criticised for having filed our proceedings on June the 5th rather than the 6th, 7th, or if it was a
Well, you could be, because you didn't wait for their response.
But it would have made no difference.
Well, you say it wouldn't have made any difference, but they told you it was premature.
Well,
I mean, you may tell me that wouldn't have affected what you did, but they would have told you it was premature. And did they refer to Archer? I can't remember in the letter. They did refer to Archer. So if you weren't aware of Archer, you would have been alerted to it at that stage.
But they didn't refer to Cooke. And
Well, never mind about that for the moment. But you were alerted. The only point I'm making to you, so you can respond, is You were put on notice of the premature argument.
We were put on notice of that,
Yes.
except that, of course, and
Okay.
therefore, perhaps, if we'd had a day or two extra to consider and file, I doubt it would have made any difference because we were all being aware of cocaine. In fact, it wouldn't have made any difference. Being aware of cocaine, you wouldn't have been able to take the risk. It's a point I have already made, but I think it's something that is.
Yes. All right. So, okay. Right. Thank you.
And the only other thing, I would say something I'm not going to say. A learned friend's opening comments on the effect of a follower notice and whether you get your penalty back if you win. We don't accept that for one moment. However, it is peripheral to these proceedings, and I certainly couldn't justify taking up the time of the court on that. I just want to put down the marker.
Well, I'm grateful.
That's all.
Anything to go?
I think he's still in
Paragraph.
40.
All right. Well, thank you both very much indeed. We'll reserve our judgments, which will be circulated in draft in the usual way, and you know the procedure. And hand down will be remote, as is the practice at the moment. Thank you all very much indeed.
All right.